Good morning, I'm Joseph Ostrowski, and I will be representing Ashford University Hospital. The allegations regarding my client are that they wrongfully disclosed the plaintiff's protected health information in response to a judicial subpoena. Now, before I get started, I want to challenge you. I want to challenge you to put all your personal bias aside, take yourself out of the what if it was me scenarios, and only look at the credited facts stated. And ultimately, I want you to make the right decision. Now, before I get started, I want to go over a couple key terms that we're going to be talking about. So what is HIPAA? What is PHI? And why does Ashford University take these allegations so seriously? The Health Insurance Probability and Accountability Act of 1996 is what we know as HIPAA. This privacy rule provides federal privacy protections for individually identifiable health information called protected health information, or as we call it, PHI. Now, this is held by most healthcare providers and health plans and their businesses associates. The HIPAA privacy rule sets out how and with whom PHI may be shared. The privacy rule also provides individuals certain rights regarding their health information, such as the rights to access or request corrections to their information. Now, some of these corrections could be phone numbers, fax numbers, email addresses, social security numbers, medical record numbers, and home of record. Now, who must comply with HIPAA privacy rule? HIPAA applies to health plans, healthcare clearinghouses, and those healthcare providers that conduct certain healthcare transactions electronically, things such as billing. These are also known as covered entities. Hospitals and most clinics, physicians, and practitioners are HIPAA-covered entities. In addition, HIPAA protects PHI held by businesses associates, such as billing services and others hired by covered entities to perform services or functions that involve access to PHI. The HIPAA privacy regulations require healthcare providers and organizations, as well as their business associates, to develop and follow procedures that ensure the confidentiality and security of protected health information when it is transferred, received, handled, or shared. This applies to all forms of PHI, including paper, oral, and electronic. Furthermore, only the minimum health information necessary to conduct business should be and is used or shared. Protected health information isn't safe from exception to policies, though. For instance, when a court order is present, a HIPAA-covered healthcare provider or health plan may share your protected health information if it has a court order. This includes the order of administrative tribunal. However, the provider or plan may only disclose the information specifically described in the order. A subpoena can be issued by someone other than a judge, such as a court clerk or an attorney in a case. And for instances like this one, when a subpoena is present but not followed by a court order, HIPAA-covered providers may disclose information to a party issuing a subpoena. And some of these cases or instances include to report a PHI to a law enforcement official responsibly able to prevent or loosen a serious or imminent threat, to report a PHI that covered entity in good faith believes to be evidence to a crime that occurred on the premises of the covered entity, or cases like this one, to comply with a court order, ordered warrant, a subpoena or summons issued by a judicial officer, or an administrative request from a law enforcement official. The administrative request must include a written statement that the information requested is relevant and material specific and limited in scope, and de-identified information cannot be used. Now, HIPAA privacy rules require additional steps before a physician can release records obtaining protected health information in regards to a subpoena. A physician may disclose PHI in the course of any judicial or administrative proceeding by either obtaining an order of a court or in response to a subpoena, if the physician obtains satisfactory assurances from the party issuing the subpoena. For the purpose of obtaining satisfactory assurance from a party seeking PHI, the physician must receive documentation demonstrating that the party requesting the information has made a good faith attempt to provide written notice to the individual. The notice to the individual includes sufficient information about the litigation to permit the individual to raise an objection to the court. And it must require the time for the individual to raise objections has lapsed and no objections were filed, or all objections that were filed by the individual had been resolved by the court. Now all three of these steps were covered by Ashford University Hospital. The party requesting the information did make a good faith attempt to provide written notice to the plaintiff. The notice to the individual included sufficient information about the litigation and gave the plaintiff an opportunity to raise the objection to the court. And sufficient time for the individual to raise the objections had lapsed and no objections were filed. Ashford University shouldn't be held responsible for the plaintiff's negligence in updating their contact information or responding to a subpoena in a sufficient amount of time. In closing, Ashford University Hospital had the right to disclose this information in lieu of the subpoena. Thank you.